Good morning. Good morning. Good morning. It's Thursday. It's July 31st. That doesn't even make sense to my brain, probably because I've been in way too many states to count over the last few weeks, which has been great. It has been a full swing July over here. You guys, it's so good to see you. We have lots to talk about today. Replay crew, love you. Everything's going to be time-stamped down below. Everything will be time-stamped down below. Let me know where you're coming in from, what you're drinking. I have a cappuccino. Dr. B did help by cleaning everything. He was like, look, I can help with the cappuccino. So, full cappuccino. But today we're going to be talking about more of not really the fallout for the Karen Read case, but like the loose ends, the things that aren't done yet, the things that I know you're going to have questions about. And then is Sarah Boone and her lawyer. We're just going to have to chat about it. There is much to chat about. Also, we can, when we get to Q&A, we can talk a little bit more about yesterday's interview with Attorney Alessi. I had such a good time with a chat. I hope that you enjoyed our chat. As always, it is my goal to have a conversation where I ask questions that you might be interested in or that I am interested in, and then have a conversation. It's never going to be so what do you think about being a lawyer? Like, that's never going to be the way I have a conversation, because I also don't consider them interviews. I consider them conversations. Jasmine in the chat said, pulling a Robert Alessi, drinking 25 ounces of water. I have not had nearly enough water this morning. Don't tell anybody. I'm ready for water, but I'm also really needing coffee. You guys, you're going to have to hear about this probably for the next few weeks. I have fallen into a rabbit hole of digital organization, because I am trying, this happens periodically. You guys who have been around a long time, you're like, I remember when you were doing this physically with your office, like until it was just right. I'm there with digital. Something sent me sideways and I was like, enough. I can no longer do this. It cannot be tolerated. So I am looking for the perfect solution for me, for the very disparate things that I do, including PDF reading. And I will keep you posted on how that goes, because I am looking for a whole bunch of different options to organize documents, because it is different than when practicing, and it is a different use case, but I need a system that works for me. And I am trying to find the right balance, because I'm also it's a whole thing, but it's very full. This one is too complicated. This one is too simple. This one is too, When I come up with a solution, I will let you know, because I have so many PDFs, and I need PDFs that, I need to be able to write on them. And so it's making sure I can get them onto the different types of devices I use to mark them up, because I don't like marking them up on the computer, because then I'm in my office till 11 p.m. And then I feel like I haven't seen my family. So yes, I am full Goldilocks. This one's too hot. This one's too cold. This one's too big. This one's too small. This one's too heavy. This one's too crooked. So I am looking for the solution that is just right, because it has to work for my brain, and it has to work for the things I need. And the things I need for PDFs are to be able to mark them up physically, but like not on an iPad, because I don't like writing on the iPad. Like, it's a tactile situation that I hate. Chronic Shock said, the ADHD tax. So I am trying to get into the right situation, and I am deep in a rabbit hole. So I will let you know when I am done in the rabbit hole of what the system is for the PDFs, because I really love the tactile of writing on them, but it's a whole thing. So we'll get there. Some of you are like, there are lots of solutions So there were lots of solutions. Is this when you build your own system? No, it's not. I don't want to build my own system for this because, we're doing all the things. But I'll keep you posted. It's just finding where I want to be for the PDFs. So I will tell you all how we go. Irish Rover said ADHD should just be called the Goldilocks syndrome. I mean, it really is. It's like, it's too hot. Nope, now it's too cold. Nope, now that one's too heavy. Nope, I don't like the way that pen feels. No, I don't like the way that pen feels either. It's just, it needs to be delightful. It needs to be open. It needs to be easy. My list is long because also I have so many PDFs that porting them back and forth and remembering when I'm sitting at my computer to put the thing I need on the thing also is a thing. So we're doing all of it. It's going to be a thing. It's just going to be a whole thing. Sweet and Salty asking the deeply personal questions in the chat this morning, which I love to answer. Yes, rising. Half of you are going, and the other half of you are going, I don't know what they're talking about, which is fine. We're going to roll the intro. We're going to talk about the Karen Reed case today because we need to talk about the motion to withdraw, the return of property and what that even means, the other motions that are going on in the Karen Reed case and where that's going to end up. And then we're going to talk a little bit about, Sarah Boone and her 75th lawyer. I'm being a little hyperbolic with that, but it feels like vibes. It's her 75th attorney. So we will deal with it. All right. So are we ready? Cheers. Let's jump in and talk about all the things. We have like much to talk about, but also we have just, Emily, are we going to spend the whole day talking about organizational systems? Not yet. But once I figure out the system that I like, we will talk about it. I will look, and it's hard because a lot of the times it's like, have you tried this? It's like, I don't like that for this reason. It doesn't mean it's not good for you. All of our brains work differently, and there are some unique use cases. I just need to find the most streamlined way to work within what I'm already working with. And there are so many options is the thing. And so I need to make sure that I haven't missed an option and that the option I've picked is the right option. But there's also a lot of dopamine in picking a new system. And I am mindful of that because then I will like system hop and I don't need to do that. So I'm like, we will see what we see. I am trying to keep it simple and within the bounds of what I already use, which is a lot of Google products. So we will get there. With that, Law Nerds, we're going to run the intro and we got a lot to talk about today. Let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the Law Nerds in the chat. They're here for the facts, not and let's get to court. What is going on in the Karen Reed case still? That's what we are going to start talking about today until we get to our questions later. Because after Karen Reed's acquittal, there are still things that are going on. We will be getting back into the civil case. It's going to take a minute to get back into the civil case for me just because I've been bouncing around so much. And as you have heard, me carrying around my PDFs so I can read while I'm on the road has become more difficult. And I don't want to do it on the computer, but I don't always love doing it on it's a whole thing. But there is much going on in the civil case. We will touch back into it. That is going to be a much longer road. Finishing out what's going on in the criminal case, I am very interested in because Karen Reed's attorneys have made a motion to release the Kraken. It was the only thing I could say. To release the sidebars, release the impoundment. And I'm very, excited about that because the judge recently extended the impoundment order. And I know a lot of you, when you think about impoundment, you are thinking about cars and things. Look, if we have not gotten to Massachusetts does it different by now, I don't know what to say. But her attorneys are asking to release the sidebars. We will talk about that motion in just a little bit. They are also asking for return of property in 2 different cases. Because remember, there was the indictment to nowhere with Karen Reed and Turtle Boy, Aiden Carney, that was not an indictment. No one was indicted, and she had cell phones taken from her in connection with that. But there's also the things that were property taken by law enforcement for the criminal case, most notably the Lexus and the cell phone. So we're going to talk about return of property on those things and where we go from there. And so there are still things happening in the criminal case. It's not all the way done. And with it not being all the way done, it's just not all the way done. So we are going to get into those motions today. But first, we need to talk about the fact that Attorney Brennan has made a motion to withdraw. I don't even know. I am trying to not be a jerk, but I don't know if I have it in me. I am tired of this man. I'm tired. I'm tired. I really am. I really am tired. So when I see, look, I am dyslexic. I am very ADHD. I typo things all the time. I really do. And I have a very difficult time when things are in all caps because my brain puts them in different spots. But when it jumps out at me, because normally your typos are going to go unnoticed by me unless I'm reading it out loud and get tripped up in the middle of a sentence. But sir, in the year of our Lord Grammarly, how is this motion to withdraw missing a letter? How is this? How is this? How? The way I would check and double check and try to triple check and occasionally have friends double check to make sure that I wasn't missing something or that there wasn't something there that I just couldn't see, which has probably happened to a bunch of you too, because we're in the same boat with this, where you have stuff that you're like, my brain literally didn't even see it because I've been working on this thing for so long. But how? I gave a pass when he spelled his own name wrong. I realize that typos happen, but it's the title. I mean, it's just, and here's the truth, you guys. Lawyers, I'm sorry if I hurt your feelings. Here's the truth. Most motions are copy and paste. Most motions are copy and paste. Most motions are copy and paste. Also, if someone at his office is sending this out, are they just like, well, you typed it. I'm just going to let it go. I don't know. But how? Just how? Commonwealth versus Karen Reed motion to withdraw. Undersigned counsel moves to withdraw from the above docketed matter. Undersigned counsel's position as special prosecutor has concluded. Sir, there are still motions pending, including the motion to return property. Like, the case isn't done. He's like, I'm out. Someone else deal with it. Are we going to see Adam Lally back in court? Well, this is from July 30th, and Hank Brennan has said, "Peace out. I am done." I just don't understand. I just don't understand how we get here. Soko said, "Is it typical for a prosecutor to withdraw? I thought that was usually for defense." Well, prosecutors normally just get, if they're no longer on a case, it normally just gets reassigned to another prosecutor. There's no like formal motion to withdraw. And this is a great question. Here's why there's no formal motion to withdraw, because it's the prosecutor's office. So you're representing the office. Anyone from the office can essentially be on that case. There are limited circumstances where that might not be true, but in broad strokes, it is the office of the district attorney. So anyone for the office of the district attorney can be on the case. He's no longer part of the office of the district attorney because he was a special prosecutor. So he's giving notice to the court, "I'm withdrawing from the case." I don't know if he needs permission or if he needs to give notice that the case will be handled by, probably Adam Lally. But yes, he's a special prosecutor. He's a special prosecutor. So I understand why, in his mind, a motion to withdraw versus notice of reassignment makes sense. But it should probably be a notice of reassignment saying, "Oh, hey, by the way, attorney XYZ will be handling this case," whoever that attorney will be for the rest of the motions, which honestly is probably Adam Lally. So I don't know. I don't know how we get here. It's just confusing to me. It really is. But you know what's not confusing to me? Cozy Casual Mobile Games. You guys, we have a stream sponsor today, and I want to make sure that we thank them. So give me a brief moment while we thank our stream sponsor, Love and Pies. Law nerds, hang with me for a minute while I tell you about a game that I'm loving right now. What I love about Love and Pies is it has a couple different components, so depending on what mood you're in, you can either really dive into the match and clear component of the game where you are matching ingredients to clear out recipes that are waiting and complete tasks and get them off your list, or the decorating side of the game where you are diving into the storyline and rebuilding and decorating your bakery. Plus, in that storyline, of course, there's a little bit of mystery. Your mother's beloved cafe has burned down under very mysterious circumstances, and it's up to you to not only rebuild it from the ashes, but uncover the secrets behind the fire. I love that I can move through Love and Pies by just merging away and listening to my favorite stream, which is probably what you're doing now. But if you're not playing Love and Pies at the moment, now is the time to download, because new users who use my link and reach day 3 within the next week will claim a very sweet treat of 200 energy and 50 gems. So download Love and Pies now using my link, and new users who reach day 3 within the next week will get a very sweet treat of 200 energy and 50 gems. And that is going to supercharge your game. So make sure to download Love and Pies using my link down below. I'm going to get back to playing, and we're going to get back to streaming. So let's go. And yes, for all of you that were like, "Emily, your screen, look," I know I keep my screen on like a more orange red setting. So when you look at my screen, it is always in a orange red setting. So yes, my phone is in an orange red setting. I love that some of you are in the chat like, "No, I'm actually playing it." Look, I get it. Because sometimes casual mobile gaming is what I do when I listen to streams too. I don't get to do what I'm the one streaming, though I need to figure that out because I think it would be fun to stream together a bit. While gaming. I think that would be great. So all the links will be linked, and there's a link in the description and a link in the chat if you are looking for them. So that's where you can find it, and you will see it in the chat. But Peanutty, there is a link at the top of the chat and then in the description as well. And if it's not in the description, it will be after I've said that. So no worries at all. All right, let's pull up our next Karen Reed motion, because we've got a motion. Well, let's go for the return of property first, and then we will talk about the impoundment of all of the sidebars etc. So let's go to, this is an article from Ted Daniel at Boston 25. We are going to start there, and I'm going to very quickly put this onto reader mode just because there's too much happening on the screen for me. But this is from Boston 25. There's the headline. We're gonna just immediately into reader mode. Immediately into reader mode. Do it. No, do it. Where's my reader mode? Come on, reader mode. There we go. When reader mode is struggling, you know it's not a good thing. Karen Reed's lawyer bewildered by delay in returning property. With her high-profile criminal case concluded, he writes, Karen Reed is now pushing for the return of her personal property, including 3 cell phones and a Lexus SUV valued at approximately $60,000, all of which were seized by the Massachusetts State Police. I imagine the purchase price for that particular Lexus was much higher than this. Like, really. Steve Bozang, who is the defense attorney that just joined, but Steve Bozang, a Dedham-based defense attorney who recently joined Karen Reed's legal team, has filed 2 motions seeking their immediate return. And normally you don't need motions for this after an acquittal. So he goes on to say, I put a call into the Norfolk DA's office and inquired about getting back the personal cell phones as well as the car. When I didn't hear back after a month, holy shit. A month? That's a really long time. When I didn't hear back after a month, it was time to file a motion and let the judge order the items be returned. Like, oftentimes this just goes to the court with a notice that stuff's been returned. This is not, Emily, why do you expect things to just go simply? This shouldn't be a big deal. There was an acquittal. You just give back the property. Oh, Emily. Silly me. Here's the thing. Let's talk about how this normally goes for a second. Normally, the district attorney would notify the lead detective or whoever is handling the case agent, whatever, that the case had concluded and that property is going to be returned, or that property was going to be returned as an agreement of a plea deal or whatever. And that with digital devices that don't need to be kept for appeal and stuff, those are regularly released. That's pretty easy to do. And then normally the DA would just notify the law enforcement, hey, this defense attorney represents this person on this case file, this evidence file, and they're getting a return of property. Of course, that can't be illegal property. It has to be legal property. So it's not like there's a plea deal. Hey, man, can I get like illegal narcotics back or something like that? Those things don't get returned. But digital devices and stuff, sure. So then you would just go to the police department as the defense attorney and be like, hey, the DA notified you I was coming. I'm here now. Can you give me the things? And then they would bring out the evidence under that evidence number. They would bring out the property slips. They would have the defense attorney sign for them. They would document that the defense attorney picked them up, what they picked up, what evidence numbers they were. Sometimes take pictures of what condition they are in so that you don't have the issue of an attorney or a defendant saying, I didn't receive these in the condition you took them in or what have you. And then they would just get turned over. The concern is, where are they in evidence? And what evidence number are they under? And how is anyone even going to find them? Because there doesn't seem to be any chain of custody. And iPhones look like fucking iPhones. Like, if they take the cases off of them, all the iPhones look like iPhones. I just wonder if they really don't know which ones are hers. Like, is that Is that possible? I think that's possible. I don't know that for sure. But I think it's possible that nobody knows exactly where they are in evidence. This is like the least of the reasons why you keep an evidence log, but it's like the side effect. If you just have good reporting, you just go to the evidence bag and are like, this is this iPhone, this is this iPhone, this is this iPhone. And they should at least know exactly what car is hers. We're going to talk about the condition of the car in a minute. So we're going to talk about the car. I worry that perhaps that's a month is exceedingly long. A month is exceedingly long. Also, SoCal folks, I know we do generally a no, and this is for our mods as well, a no breaking, but let just everybody check in on each other. It is fine with me. To everybody whose earth is rumbling where you are, I am sorry. I know 100% that feeling. Stay safe and take care of yourselves. And stream will be up for replay if you need to go do the things. You're all good. But mods, it's okay. Let the SoCal folks check in. It's not breaking news that's going to derail me in that way. So everyone in the chat, it's okay if we'll be on replay. It's all right. Take what you take your time. Glad to see everyone's good. So thank you, mods, also, because we really try to make sure that I don't get derailed. That's part of our no breaking news, is that I will get derailed. But again, checking in on each other is part of our community. So it's been rumbly. So take care, stay safe. SoCalers, you know it. Anyone new to SoCal, now you feel like you're officially in SoCal. So at least it's daytime. Okay. So they asked for this a month ago. It's bananas to me that they still don't have it. I wonder truly if this is that either no one knows who's in charge, no one knows where to find it, or no one knows what they're doing. Right? When I didn't hear back after a month, it was time to file a motion. This normally wouldn't have to go to court. As Boston 25 News reported on Monday, the attorney, Bozang, first filed a motion to reclaim Reed's 2021 Lexus LX 570 and one personal phone. On Tuesday, investigative reporter Ted Daniel obtained a second request filed by that attorney for return of two additional phones belonging to Reed. Those two phones were seized by the state police in January 2024 in an attempt by Special Prosecutor Ken Mello to indict. Look, when I hear the word Mello, I don't know if that's how that's pronounced, but I've been in the DCI. I am in band headspace. So I'm thinking about, well, honestly, the first thing that popped into my head was Boston's Mello feature where everyone's playing their someone else's instrument because it's bananas. So we're too close to finals and my brain is buffering. I am sorry, Mr. Mello. I know we are not talking about the instrument, but my brain has gone there. So Special Prosecutor Ken Mello to indict, or during an attempt by Special Prosecutor Ken Mello to indict Karen Reed and Aiden Carney, the content creator known as Turtle Boy, on witness intimidation charges. That didn't go anywhere. Also, if not indicted, I can understand why they held on to the phones at the end of trial, but this should be an easy, give it back. Anyone in law enforcement, one of the central features, especially of detectives, because detectives have way too much paperwork to do, get it off my desk. Does anyone else feel like that at work? I want to handle it immediately and get it off my desk. Get it off my desk. This case is done. Get it out. Get this stuff out of evidence. Get it back to where it needs to go. I want to be done. That's clearly not what's happening here, but that is what I am used to is the please have it done. Give it back. The Karen Reed's attorney say that when they returned no bill, which means they didn't indict, meaning there was no evidence whatsoever that Karen Reed or Aiden Carney had committed any crimes, the attorney said, I'm bewildered why those phones weren't turned back over immediately. I can understand, though I don't agree with the DA's office being like, we're going to hold it till the end of trial. We might attempt to reindict. I can see that. But also, if you've already downloaded everything off the phones, why do you need the physical phones? Like if you've already dumped them, you don't need the physical phones anymore. The attorney said, when asked if he had received any rationale for the continued retention of the items, quote, well, I think the civil lawyers may have some interest in it. He added, the civil lawyers can fight in another case if they want phones or cars or anything. I think he's talking about, Emily, keep reading. Ted Daniel writes that he is referring to the wrongful death lawsuit filed by the family of John O'Keefe against Reed, which is a civil case currently pending. Ted Daniel goes on to say, Boston 25 News has reached out to the Norfolk DA's office to ask why the items have not yet been returned to Reed and if there are any established protocols for their return. I mean, this is not hard. Late Tuesday, the office emailed a reply of no comment. If you took the phone and did the extraction and then returned it, you wouldn't have to deal with this. I'm just saying. Also, the law enforcement holding property because a civil wrongful death suit might want it is not proper. Shockingly. It doesn't matter. They might want it, but they don't get it. That's not the job of law enforcement. Your investigation is done. Your investigation has been done. The car makes sense to me, but you don't need the physical digital devices anymore if you did a phone extraction. Just return them. And so annoying. But here's the other thing with this. First, well, no, Emily, pull up the rest of the docket. I'm going to pull up the rest of the docket because I don't have this motion. Massachusetts is. Emily, you keep saying it's special. It is, but the dockets are not nearly as easy to work with. So I'm going to just show you what the docketed item is. And we'll see if there's anything else from today too, but I'll pull up the docketed item. Return of property should be fairly straightforward and simple. And it's not as if this DA's office never handles cases. There should be a regular course of practice. And the course of practice with phones should be once the extraction is done, the phones get turned back over. Unless the physical phone was used as evidence of something. And that's, a possibility that the phone itself, the physical item, is evidence, but it's the more rare outcome that that's true. It's generally the data on the phone that they want. Once there's an extraction, you don't need the physical device anymore. So are you worried that you're not doing extractions properly and that's why you're trying to keep all of them? It's incredibly frustrating to me because it's just, Emily, you keep saying that's not how it should go. That's not how it should go. Give them back the phones. And then you don't have to worry about the phones not getting returned. A month? Just a month? It's silly. I shouldn't be surprised at this point. Hold on. I can't, wait, what am I doing? I don't even know. I need to be able to move this to just the side and it's fighting with me. Hold on. Sorry, chat. 1 second. We're just pulling up oh no, I undid it. I accidentally undid the slide I was on. Boo. I did this badly. All right. We're going back to the docket real quick because somehow I back tabbed improperly. So we're going to pull up those docketed items in just a second. Apologies for the scrolling. It is what it is. There are a lot of docketed items in this case, and their docket's difficult to deal with. All right, there we go. No! What? That's not me. No, I don't. Ah! The tech is teching. The tech is just teching. Just give me the docket. Apologies for scrolling. It's lots of scrolling. Why? Like, why do we there? Oh, goodness. This website is just like, me. Stop it. Okay. June 27th, 2025. Order to extend June 18th, 2025 impoundment order. I imagine that generally deals with the jury, though I don't have a copy of it. 728, attorney appearance. This is the attorney who we just saw quoted by Ted Daniel, who was added for defendant Karen Reed. 728, defendant's motion for return of property. We're going to take a look at that today because they asked for it after the verdict. And then we're like, yo, where is it? July 30th, defendant's motion for relief from April 14th, order to impound sidebar conferences. We're going to talk about that in just a minute. Affidavit of counsel in support of defendant's motion for relief. We're going to go over it. Commonwealth's motion for permission to return physical evidence to defendant from 7:30. I don't think you need permission from the court. It's not being held for appeal. You can just tell law enforcement to give it back. But when it comes to the Lexus, she's going to have to go have it towed out of police custody because it's my understanding from everything we've seen that the Lexus does not work because they did the chip off of the motherboard and the car won't even turn on. So the car is, I don't know if it can be repaired because of the way they took apart all of the components from the motherboard and stuff. I don't know if that can be fixed. I think it's Hank Brennan. I have no idea why this says Henry. Did he sign his motion with the wrong name? Hold on. It also says motion to withdraw spelled properly. Let me see what he signed his motion as. Let's switch to his motion. No, he signed it Hank. So I don't know why the docket says Henry. Is his full name Henry? A lot of you in the chat are saying Hank is short for Henry. His full name's Henry. Okay. So he signed the motion Hank, though. If his appearance is under Hank, everything should be under Hank. Sure. I don't even know. I don't know. He goes by Hank, but I don't know if they have been calling. I don't think I've noticed them calling him. Well, they haven't. They normally put prosecution motion. I don't think we've seen him referred to by full name on the docket in other motions, or at least not in a way that has stood out when we've gone through it. So let's. Doctor Who in the chat said, I'm going to call him Steve. Someone in the chat named Steve is going to take issue for sure. I don't even know. I don't know. We just are where we are today. Are we ready to talk about the motion to return property? Let's talk about the motion to return property. This is a motion that shouldn't have had to be filed. It's dumb to me that it needs to be filed. It's been a month. More than a month. Just give back the cell phones. It's easy to hand back the cell phones and then simply set up a time for a tow truck to come and grab the Lexus. Oh, okay. We're going to go through the motion and then we're going to answer some of your questions. I know I will not be able to answer all of your questions, because you are going to have questions about the damage to the car that are going to depend on insurance and other things that we will not know yet. So let's look at the motion to return property. This is a very brief motion. Ted Daniel shared a photo of it on Twitter or the Bird app or the former Bird app or whatever. I know, Emily, it's disrespectful not to call it by its name. I don't care. The Bird app is... I can't. It's just still Twitter. Motion for return of property. It's not your eyes. It's not your internet. It is, in fact, this motion. It is so difficult to see. Motion for order to return property. This was filed July 28th. Now comes misreading the above entitled matter and respectfully moves pursuant to Superior Court Rule 61 that this honorable court order the return of all of Ms. Reed's personal property, including but not limited to the following items: 2021 Lexus LX 570, personal cell phone. As reason, therefore, counsel attempted to negotiate the return of the listed property with ADA Adam Lally in late June. Attempted to negotiate the return of property with ADA Adam Lally in late June, as property is in the possession, custody, and control of the Massachusetts State Police and has not heard back. Thus, counsel is respectfully requesting this honorable court order the return of the items immediately. Well, anyone shocked? This doesn't even get a surprise Pikachu face. Adam Lally is just like, you don't have it back yet? Okay. You just have a checklist. Just give it back. There's no reason to hold on to it. Aren't y'all tired of having it? I'm interested in this because, again, we are so far into the realm of shit that shouldn't be happening that I am still continuing to buffer, because these are things that are a regular, easy, and normal part of the job that just happen or should happen in a routine way. Property gets returned. It shouldn't even have to go through the court. Yeah, I asked law enforcement. I left them a message. They didn't get it back to you? Weird. So the question that all of you are going to ask, what about the Lexus? What about the damage to the Lexus? There's not much that can be done about the damage to the Lexus. We'll see if her attorneys try, but the way that the Lexus was taken apart was part of the investigation. And because of that, she's going to have to fight it out with her car insurance. And I don't know what car insurance in a given area chooses to do, because all of the vehicles that I dealt with that were in evidence and part of an investigation were in substantial vehicle collisions. Like, I worked a lot of vehicular homicides and all of the vehicles were totaled. Karen Reed's vehicle was not totaled until the investigation took it apart. So it's actually a very unique situation in that the vehicle was damaged as part of the investigation, but it was not already damaged and undrivable. So I don't know what insurance will do with that, but it's my understanding from everything that she is still paying for the car. I don't know if the car can be put back together. I don't know if you can take it back to Lexus and be like, can you put it back together again? Or if you just, I don't know, sell it for scrap. I don't know what you do, but it'll be interesting to see what happens with that. I don't know the answers. I imagine on Karen Reed's end, she probably, and this is just purely my speculation, I would imagine she doesn't want to drive it. doesn't want to own it and doesn't want to still pay for it and just wants to be done with it and get rid of it and just be like, done, or fix it and sell it or whatever. But I imagine she would be ready to be done with the vehicle, but it is something that she is still paying for and needs to resolve dealing with that. And then as to the cell phones, much easier to either wipe them. I don't know. Let me know in the chat if you are in Karen Reed's position and you get back, it sounds like 3 devices. No matter what you do to those devices, do you trust those devices? Maybe I'm just a highly suspicious individual. Sometimes I'm not. Sometimes I'm just a Labrador and I'm just like, everything's fine. But if I got those back, I would want nothing to do with those devices. You can wipe them all you want. Those are immediately getting like, we're selling those back the fastest we can. They would be rehomed. They would be 100% rehomed. Rehomed immediately. I might have an investigator take a look at them for curiosity. I might do that. I might get a tech person to take a look at the phones and see if I can figure out what they had done. I might do that. I might give them to the lawyers and see and have a digital examination done out of curiosity. I might do that because I think her lawyers probably have questions and might want to take a look. So maybe having, again, it's going to depend on how much energy can go into this, but maybe having those investigated and then getting rid of them. I'd be really interested in that, but I wouldn't want them in my house. So there's that. But she still has the right to them back. Robin Richardson asked, what happens if they can't find her property? They generally have to pay you for it. Though I imagine trying to get them to do that would take court orders and a fuck ton of time, but they generally have to pay you for it. Generally, if your property is damaged in police custody, not part of the investigation, because Karen Reed's Lexus was damaged in police custody as part of the investigation. They took apart the motherboard, etc. That's different. But if your car is impounded and then like a rock falls on the windshield, then you generally have to deal with insurance and be compensated for it if your car is impounded for parking tickets or something and then is damaged, and you often need an attorney to help with that. That's a different situation than the situation of the car's damage as part of the investigation. But it's like when you look at the Baldwin case, the Rust shooting, the gun was destroyed as part of the testing, but the movie production company paid for that property and has a right to that property, but it was part of their investigation that destroyed the property. So they don't really have bunch of an argument there, though. If it hadn't been damaged and was just investigated, the Rust movie company could make a motion to get the weapon back because it is part of a movie set, different than a unregistered gun or something like that. So it just really, really, really depends on the case. These are things, look, the reason I bring up the return of property is because even when it's done, it's not done. So even when a verdict has come down, even when there's an acquittal, even when there's not going to be any appeal, it's still not done. And that's the difficult thing in criminal cases, is it's still not over. We've talked about this a little bit in connection to the Kohberger case. And in connection to the Kohberger case, one of the things I said quite frequently with the plea deal is that the plea deal makes that case just about as done as it can be. And so there is some finality to that because there will still be things happening that mean a case is not done yet. But with the type of plea deal Kohberger took, it is going to be more complete than other cases. So, with all of that, we will see. I'm going to keep an eye on it. I hope her attorney will or Ted Daniel will follow up. I hope that someone will circle back. Someone circle back with us and tell us if she got her shit back, because this is preposterous. This shouldn't be hard. You just give it back. All right. Emily, you can't just bang on about what should happen. Clearly, what should happen and what does happen are not the same in this case. And it seems in Massachusetts and other cases too. It's so frustrating. And I really hope that everyone in Norfolk County, in Massachusetts, if you have been telling people, no, this is what's going on, and people have been like, I mean, for real though, I hope you feel seen. I'm still baffled that this is seemingly not just this case, and it seems that this is just what's happening. And I don't have adequate words for my level of frustration, because these are simple procedural things that should just be happening. It's part of why I pulled up the police reports in the Idaho case from the Moscow Police Department to show what that looked like. To give an example of, look, that is a massive case. And there were a ton of law enforcement working on it. But they noted everything. Everything. This officer took a break at this point, and this officer stepped in. They noted everything. So it's baffling to me that the attitude here is, meh, it'll be fine. No wonder the defense attorneys are losing their mind in this jurisdiction. Sometimes defense attorneys can be hyperbolic. It is part of their charm. It is part of their work. This is not them being hyperbolic. This is them being tired and mad and saying, I don't understand how nothing is happening the way it should happen. No one should wait 3 years to have a search warrant turned over. No one should be waiting a month after an acquittal to have a phone turned over. Like, I can see if it takes a week for people to be like, oh, we need to get it out of evidence. We need to document it. My bad. They should be saying that. But there's no reason that there should be no return call unless Adam Lally like, I'm not the attorney on the case. Go talk to Brennan. Fucking wild. Fucking wild. But on a positive note, let's talk about the impoundment of the sidebars, shall we? Yeah, we shall. We're going to coffee a little bit too. We're going to coffee a little bit as we talk about the impoundment of the sidebars. Emily, you're too happy. Emily enjoys a good sidebar. It's going to be a lot of sidebars, but we enjoy. I need my process for PDF reading, highlighting, documenting, and saving to be a 1010 before we get all these sidebars. Because, oh bitch, there's going to be so many of them. There's going to be many. There's going to be many. Defendant Karen Reed's motion for relief from the April 14th, 2024 order to impound sidebar conferences. Now comes defendant Karen Reed and respectfully moves this honorable court to release the transcripts of sidebar conferences that occurred prior to and during the two trials in this matter from the court's April 14th, 2024 order of impoundment. As grounds for this motion, Ms. Reed states that good cause no longer exists for impoundment. Yeah, the case is done. Ms. Reed relies further on the attached affidavit of counsel, which is incorporated herein. Background. On April 10th, 2024, the Commonwealth filed its motion in limine for appointment of court stenographer, ongoing order to impound all sidebar conferences, and impoundment of juror names during trial. I have no problem with impoundment of juror names. I really don't. If jurors want to come forward and talk, they can. If they don't have to. I have no problem with impoundment of juror names. It does not bother me. The Commonwealth sought impoundment of the names of all jurors, all sidebar discussions, including sidebar discussions during pretrial proceedings, which was so dumb. It's like, this doesn't need to be at sidebar. There should be very limited things at sidebar during pretrial. There's no jury there. And the only things that should have been at sidebar during this were things about the federal investigation, because those properly should have been sealed. The Commonwealth sought impoundment of the name of all jurors, all sidebar discussions, including sidebar discussions during pretrial proceedings, and that sidebar discussions and juror names be unavailable until a verdict is returned. Again, I'm fine with them extending the juror names. The Commonwealth's rationale was that, quote, the publication of matters discussed at sidebar, including juror names, information, and potentially sensitive responses to inquiry while the trial is ongoing could prejudice the parties and expose jurors to extraneous matters. I do not have a problem at all with impounding the juror names and impounding the sidebar of jury selection. There is nothing that needs to be done with that. A juror going to sidebar saying that they had and this is an example just from my personal cases and experience with prosecuting cases, but in a potential DUI related fatality, you will probably get a number of jurors going to sidebar to say, I had a family member killed in a DUI related crash. I had a family member convicted in a DUI related crash. They will share personal details about why this case might be a difficult case for them to sit on. If a juror had been a victim of crime, they will often share that at sidebar and say, it's going to be hard for me to be on this case because my experience was this. So there are a lot of personal details that jurors will share at sidebar as part of being honest and transparent in the process that I'm fine with leaving sealed. Nobody needs all their business on the street, and it will discourage jurors in the future from even showing up on their juror summons if they think that something they share that people might not know about them could be released to the public, especially in a high-profile case. Seal it, fine. Impound the juror sidebars, fine. And if you needed to unseal them for appeals, you can unseal them for that purpose for the appellate court and not for the public. I'm fine with all of that. Go right ahead. But when it comes to the legal rulings, those should not be sealed. Jurors' business, fine. Jurors' names, fine. But when it comes to the legal rulings and the facts of the case, release the rest of it. Just release it. Legal standard. Rule 7 of the Uniform Rules of Impoundment provides that a judge evaluating a motion to impound documents may enter an order of impoundment only if good cause to withhold the documents from the public is shown. Again, I think the jurors meet good cause. I think the rest doesn't. To determine whether good cause is shown, the judge must balance the rights of the parties based on the particular facts of each case. And then they cite case law regarding that. We know what good cause is. We've talked about this quite a lot. After a verdict, most of the good cause is going to be fair trial. That ship has sailed. Once entered, an impoundment order remains an interlocutory order subject to continued existence of good cause, which means it's ongoing during the case. Unlike other orders or judgments, an impoundment order carries no continuing presumption of validity to sustain it against a proper challenge subsequently brought. A party seeking the release of impounded court records does not bear the burden of demonstrating either that there has been a material change in circumstance or that whatever good cause may once have justified their impoundment no longer exists. The burden of demonstrating the existence of good cause always remains with the party urging their continued impoundment. A proper challenge to the continued validity of an impoundment order is raised whenever the party seeking to modify the order, comes forward with a non-frivolous reason to do so. Okay, they're done. Sure. Argument: because good cause no longer exists for the order of impoundment to be continued with respect to the sidebar conferences, and because access to those materials is required for trial preparation, the impoundment materials should be released at a minimum to the parties. No. We want them. Please, we would We would also like them. Please don't just limit it to the parties. I'm real curious about some of these rulings. Like, I want to know more about the federal investigation. Please don't keep them. T.S. Lizard Wizard asked in the chat, is the prosecution saying they should stay sealed? The prosecution has not responded to this at all. So we have not seen the prosecution respond. We saw Hank Brennan file a motion to withdraw, and he's like, not my problem. Not my problem. So we have not seen that. This was just filed by the defense. And this, when they're talking about preparing for trial, they're referring to the civil trial. So let's continue on in this motion. If any of you are curious, and I'm sure some are, yes, you can have a civil wrongful death trial after an acquittal. The standards are different. Some of the rules of evidence will operate differently because the posture of the case is much different when you are looking at a civil case versus a criminal case. So yes, and yes, you can have different results on a wrongful death case than you have on a criminal case. So yes, a wrongful death case can move forward even after an acquittal, which I know seems counterintuitive, but they are different, very different standards. An order of impoundment related to the sidebar conferences was entered by agreement on April 14th, 2024. On November 13th, 2024, the court further ordered that certain transcripts of sidebar conferences be provided to counsel and the court. See Exhibit Docket. The court issued a separate order for impoundment of the list of jurors for the second trial on June 18th, 2025, and extended that order on June 26th. That's what we thought. When we saw the extended impoundment order on June 26th, I said that's probably relating to the jurors. We saw that on the docket. This confirms that that is in fact relating to the jurors. I don't have a problem with that. Fine, do it. I'm sure there will be some reporters that are like, we have the right to everything. I mean, sure. I would err on the side of protecting jurors and protecting the things that they share with the court candidly versus the public's interest in needing to know. Jurors that want to come forward and talk know well where to do it. It's not like they need the newspaper to go knock on their door so they can be heard. Anyone can get on the internet and share what they want to share. So there's no need for me. The attorneys go on to say, in accordance with these orders, the identities of the deliberating jurors in both trials in this matter remain impounded. Good, leave it. That aspect, the identity of the jurors of the Commonwealth's April 10th motion, remains unchallenged here. Good. As the issue of juror identities was subsequently addressed by the court, Ms. Reed instead seeks only the release of sidebar discussions that took place during trial. Good. And those that addressed evidentiary rulings prior to trial because the, quote, good cause the court recognized when impounding such conversations no longer exists now that a verdict has been rendered. Agree. Absolutely agree. Good. Fine. Originally, the Commonwealth was concerned that the release of sidebar conference transcripts during the pendency of the first or presumably second trial could expose jurors to extraneous matters. I mean, we all wanted to see them. So yeah, if the jury is on the internet looking at this case to the depth that they are seeing coverage of sidebar conferences, they're probably not going to be jurors on the case anyway, but I get the argument, especially because some of those sidebars involved a federal proceeding and there was much unknown about whether that was proceeding, not proceeding, or the rest of it. However, the attorney goes on, now that the trial has concluded, the issue is moot. It is. It's moo. I agree. Moo. It is moo. As the Commonwealth noted in its motion, after a verdict is returned, the potential prejudice to the parties will be greatly lessened, and that all parts of the record, except any that the court specifically finds subject to further impoundment for good cause, would then be made available to the public. The court has found that the identities of the jurors should remain impounded until and unless otherwise ordered by the court. Agree. With regard to sidebar conversations, however, good cause no longer exists for such impoundment. Such discussions should now be part of the public record. Yes, they should. Yes, they should. Yes, they should. In balancing the public's right to inspect documents against a defendant's rights guaranteed by the Sixth Amendment to a fair trial, a court must consider a variety of factors. Again, we covered almost the same argument in the Koberger case with regard to the non-dissemination, e.g. gag order. Same arguments. The right to a fair trial, the right to an impartial jury, the right for the public to not know some of this is moot because there is no further jury. There will be no further jury. All of it is moot. A lot of you are asking, will this cover both trials? Yes, this will cover both trials. It goes on to say there are at this juncture a few aspects of the case that have not been explored in depth publicly. Oh boy. In fact, in its determination to continue the order of impoundment regarding juror identities, the court noted that, quote, this case has garnered significant and divisive attention in Massachusetts and across the nation. In other words, virtually every issue in the case, especially following a completed trial, has already been disclosed. This factor weighs in favor of ending the previous order of impoundment. Agreed. Another factor, the nature of the documents under impoundment, also weighs in favor of their disclosure. As noted, Ms. Reed herein seeks only release of sidebar conferences, not the identities of jurors subject to previous orders. To the extent deliberating jurors could have been exposed to the extraneous information the Commonwealth referenced in its April 10th, 2024 motion, that concern ended when the jurors' service and with the jurors' service at the second trial. Right. Agree. Additionally, there are few, if any, privacy interests implicated by evidentiary discussions at sidebar. The extent of the community interest also weigh in favor of release of the sidebar conferences from the order of impoundment, even while acknowledging the court's, quote, duty to minimize the effects of prejudicial pretrial publicity. Again, moot. There is no more pretrial. And, well, no, this court's not concerned with that. I was going to say, well, there could be a trial in the civil case, but that's not this court's concern or jurisdiction. So there could be a trial there, but that's not the issue here. Though Ms. Reed does not bear the burden of establishing that good cause no longer exists for the order of impoundment to remain in effect and need not establish a material change in circumstances, it is apparent that any good cause that did exist during the trial for the order of impounding sidebar conversations is no longer present. The factors the court must consider in determining whether to continue its previous order of impoundment all suggest that the referenced sidebar conferences should now be part of the public record of these proceedings. Yeah. For these reasons, Ms. Reed respectfully requests the court release any sidebar conferences that occurred during either of the two trials in this case and any pretrial sidebar conferences dealing with evidentiary issues. Oh boy. Ms. Reed also respectfully requests that the court allow this motion administratively without a hearing. Yeah, just sign it, is what they're asking for. We'll see if the court does that. Affidavit of counsel in support. This is not your internet or your eyes. This part of the motion is hard to read. This is from one of the civil attorneys, not from the criminal attorneys. This is going to be so many sidebars. So many sidebars. The sidebars from both trials are still under impoundment. Yeah. Attorney Damon M. Slegson? Damon S. Do hereby depose and state the following is true to the best of my knowledge and belief. Attorney practice in Massachusetts, represent defendant Karen Reed in connection with the above captioned matter. I have reviewed the Commonwealth's motion for the appointment of stenographer. I've reviewed the court's order. I've reviewed the January 27th, 2025 order to extend. The court has found that the identities of jurors should remain impounded until and unless otherwise ordered by the court. Agree. Defense is not contesting it. Pursuant to the court's allowance of the Commonwealth's motion on April 14th, 2024, sidebar conferences remain impounded. It is not the defendant's burden to establish good cause or change in circumstances. A verdict has been rendered in this case after a second trial. There is no longer concern that public dissemination of sidebar discussions could prejudice the jury pool. I wonder if the argument would be made. I don't agree with it, but I wonder if the argument would be made that there is still a pending civil trial, but that's for the judge in the civil trial to argue, not for this. I also believe that the verdict constitutes a material change in circumstance justifying a modification of the order. In reviewing the case law surrounding relief from orders of impoundment as discussed in the motion, I believe the factors the court must consider weigh in favor of releasing the sidebar. I don't disagree. So, Karen Reed's attorneys are asking for the sidebar conferences to be released. And interestingly enough, when they titled this motion, let's get to the top of this motion. When they titled this motion, they indicate that they need the sidebar conferences in preparation for trial. So when we look at the request, where did it go? I know I read it. I am looking for it, where they said they needed it to prepare for trial. Unless my brain is just adding that in, because I know it's in there somewhere. But we went through it because there is still a civil trial pending. And they are asking for just the legal rulings, not the juror names. So Karen Reed's attorneys want all of the impounded or sealed sidebars not relating to the jury to be released to counsel and ultimately to the public. That is going to cover the sidebars from both trials. That's a substantial amount of sidebars because they didn't just do sidebars at trial. One of the things I was so frustrated about between the first trial and the second trial is that when we were getting into the second trial, all the pretrial hearings, they went to sidebar with stuff too. And so there was a ton that was happening at sidebar that I am interested to see. And we can summarize it. We probably won't go through every single sidebar, maybe the spicy ones, because we know there were some of those. But it's going to be a substantial amount of transcripts. At some point, we will go through them if and when they are released. But it's interesting to see that they are still impounded. And that order doesn't automatically terminate when a verdict is reached. So the defense is still needing to make motions asking the court to remove the orders that have not yet been removed. I will be keeping an eye on the docket. I don't see a legal reason why these should remain sealed. We haven't seen opposition to this motion. The defense attorneys asked that this motion be granted without any hearing or argument on it, which makes sense because, like the gag order in the Brian Kohberger case, the risk of prejudice to a potential jury does not exist. I'm interested to see if anyone makes an argument that because there may be a jury in the civil matter, that perhaps there still is a jury, but that is a separate matter from this. It's not the same. And this is not being heard in that court. There is no more jury in this cause of action. I don't think the argument that there might be a civil jury stands. It is a completely different matter to decide. And the entire two trials were public. So the shit's kind of out of the horse on that one. I will keep you posted. We will see what happens with the Karen Reed sidebars. I imagine that they will get released. I will be surprised if they don't, because there is no longer good cause to keep them sealed. Could I see an argument that discussions of any federal investigation could remain sealed? We'll have to see. I don't know if anyone's going to make that argument, though, because Brennan has asked to withdraw from the case. I don't think Lally's going to file a motion. So we'll see what actually gets released and what doesn't. But I am very curious at this point because, well, there's so much we don't know still. There is still so much we don't know. And at this point, this should all become part of the public record. And we're going to continue to learn more about this case. Are we ready to move on and talk about Sarah Boone's attorneys? Are we ready to talk about Sarah Boone's attorneys? Me too. Me too. Space Cat. Yes, it was at the beginning. At the beginning, we talked about Brennan withdrawing. It, W-I-T. The wit is drawing. He is withdrawing. Let's talk about Sarah Boone, and then we'll get to Q&A. I know. Emily, just 2 topics? Yes. Why? Because I still haven't unpacked from Wisconsin and Illinois. I still have stuff I haven't unpacked from when I was in Texas. I just put it into the bag and took it with me. And then it's like next week that we're on the go again. So I need to try to figure out what state I'm in because I just don't know anymore. Let's talk about Sarah Boone. Lord. For any of you that are new to the Sarah Boone case, oh my God. Nothing is more true. Sarah Boone, it's been 84 lawyers. For any of you who are new to the Sarah Boone case, Sarah Boone had a protracted and extended wait for trial because she and her attorneys did not necessarily see eye to eye. They were state-appointed lawyers. I think there was a disconnect between her expectations and what her attorneys would and should actually do. Sarah Boone did not believe that her attorneys were focused enough on her and her case. And from going through the trial and watching the police interview, it seemed very much that Sarah Boone was like, I am entitled, mild, to your full and undivided attention. And if you don't agree with me, it's because you are wrong. I am not wrong. Because Sarah Boone told us in her interviews that she excels at everything. What I appreciate about Sarah Boone, and I am taking a page from Judge H, what I appreciate about Sarah Boone is that when she does not get her way, she does tell us how she really feels. And she completely crashed out, which again is it's just a great phrase because there's nothing to explain the letter she filed with the court after sentencing. There was no words for it other than a crash out. She had a full fucking crash out after sentencing. She was convicted of the second-degree murder of her partner. She zipped him into a suitcase. She said she was just playing. She left him there in the morning. Well, he was no longer alive. She video recorded herself taunting him. It was horrific and disgusting and chilling. The case against her was quite strong. She wanted to run a battered spouse defense, or a battered, as they called it in Florida, a battered woman's defense. But the jury was like, no, that's not happening, which doesn't discount that there was violence between Sarah Boone and George. But the jury finding said squarely to me that at that time, Sarah Boone was not in danger from George. And she was not in fear, and she was not at risk of being harmed by him. She was offered a pretty substantial or a pretty beneficial plea deal, denied that plea deal, and was sentenced to life, period. Sarah Boone did not appreciate that even though she might not have had the mens rea or intent to commit murder, she had the intent to zip George into the suitcase and leave him there, and did that with disregard. So it was a second-degree murder. Though I think many of you, when you watched the trial, looked at that and went, they could have gone for a first. Like, we've seen a variety of cases that I've covered on this channel. When you look at like a Karen Reed case, you look at the Karen Reed case and go, why are you filing this? And then on the other side of it, you look at the Sarah Boone case, and a lot of you are like, they could have charged her with a first-degree murder. A lot of you were like, they could have charged her with a first-degree murder. The second-degree murder gets a life sentence, or has the option of a life sentence, and that's what the court ordered. It was a life period sentence on a second degree, which was kind of wild to me because that's a pretty high punishment on a second-degree homicide. But here's the thing about not taking the plea deal. The judge sees all the evidence. And by the time we got to the rebuttal case in the Sarah Boone trial, I was sitting there going, oh, yeah, what the fuck? Because the rebuttal case brought in a substantial amount of video evidence showing Sarah Boone being abusive to the victim in the case. And so the court knew a lot more about Sarah Boone that wouldn't have come in. And I can only imagine after trial, in hindsight, all of the defense attorneys that went before, and there were 8, 9, 10, 7,000, all of the attorneys that went before said to Sarah Boone, this is my speculation, said to Sarah Boone, we are not running that defense, because if we run that defense, all of this video that you took is coming in. And this video, you are done. And I think Sarah Boone said, these videos show what I am saying, what was done to me. Sarah Boone's perception of those videos were filtered through a lens that didn't comport with how the jury or most other people would see them. And her attorneys were like, no, I am telling you how a jury is going to see this. This is, again, my speculation. I am telling you how a jury is going to see this. A jury is going to see this and go, that is murder, and you are done. And so I imagine that was the disconnect between her and her attorneys. And the last attorney who parachuted in said, if you want to run this defense, we will run this defense. And it opened the door for all of the videos to come in. And they definitely showed a pattern of abuse. They did not show the pattern of abuse that Sarah Boone thought they showed. And they were incredibly difficult to watch. It was tremendously sad. And then at sentencing, Sarah Boone edited her sentencing statement and modified it. And then after the judge sentenced her to life, she said, you know what? Fuck that. This is what I really wanted to say, and sent it to the court with a note that she had held back what she was thinking. And then she was going to let everybody have it, including the judge. So after sentencing, when she didn't get what she wanted, full crash out. And we covered both the sentencing and the rest of it. Everyone, in her opinion, wronged her, and it was everyone else's fault. If any of you have dealt with people that have the personality traits of Sarah Boone, you will recognize them off the top and be like, oh, that's exactly what it is. That's just what that is. Sarah Boone is now trying to appeal. her initial defense attorney who parachuted into the case very confusingly filed the appeal in a circuit that doesn't exist in Florida. I think it was probably a typo, but filed it in a circuit that didn't exist. 2 appellate attorneys were appointed. The first one was appointed and I either conflicted or could not take the case or what have you. The second appellate attorney was appointed in December of 2024. Sarah Boone filed a letter that we covered just a few days ago. And when she filed that letter, we went over her filing saying, my attorney's not contacting me. And wildly, I have all of these friends that are contacting this attorney every single day, and the attorney's not calling them back. First of all, attorneys can't discuss your case with anyone but you. Second of all, I'm sure the attorney is thrilled that their email and voicemail or whatever is getting blown up a million times a day by people on behalf of Sarah Boone. I also think that people should be kept in the loop about their cases. I am not sure that that hasn't been done here. The thing is, with appellate cases, it takes a long time, because it took, in this case, quite a substantial amount of time to get the transcripts. And an appellate attorney can't do anything until they get the transcripts. So you can't really file an appellate brief until you have the transcripts. And the transcripts in this case took a while. I don't doubt that the attorney, I mean, Massachusetts has made me question everything, I got to be honest, but it's not unreasonable that the attorney would have said, I cannot file your appeal until I have the transcripts. Once I have the transcripts, it's going to take me X amount of months to review them and write your appeal. I will be in touch then. So the attorney, by way of an update, has filed a notice of extension. Then she filed the notice to the court after that notice of extension. The notice of extension was filed July 1st. Hey, the request for extension was filed before that, July 1st. Let's just go through these documents real quick as way of road so far. The court said, yes, you can have an extension. Let's pull that up real quick. We're just going to go through the brief road so far. Hey, can we have an extension? July 1st, the motion for extension of time is granted. The appellant shall serve initial brief within 60 days from the date of this order. So 60 days from July 1st, the appellate brief is due. On the 8th of July, Sarah Boone filed her notice to the court that we covered. I don't remember what day it was. The mods will remind me. Mods, just let the chat know. I don't remember what day. I don't remember what day it is today. We covered it not that long ago. She filed with the court saying, excuse me, Your Honor, you appointed counsel December 18th, 2024, and court-appointed counsel Joshua E. Adams has sent a single basic introduction via inmate messaging on February 27th, 2025, asking if she had any information and to not hesitate to contact him with. And he has not contacted her in 7 months. And third-party representatives made her aware of the order for extension, etc. So, Your Honor, my attorney is not communicating with me. Make them talk to me. And she actually asked the court to make them communicate. Appellant respectfully requests this honorable court to please advise, which the court can't do. The court can't tell Sarah Boone what to do. Please advise and take notice of these violations and either compel court-appointed appellate attorney Joshua E. Adams to fulfill his legal duties and communicate immediately, or appoint new counsel capable of necessary communication and representation and inclusion of the appellant. In 7 months, her attorney should have told her what was happening with the case. I agree. And we have not heard from the attorney whether he did or didn't, because it gets into a little bit of a pickle because those are attorney communications. Christina asked, question, is this the same judge she told off in her sentencing email? Yes. So She filed that on July 8th. And on July 28th, the attorney filed a motion with the court. So it seems that Sarah Boone is getting her wish and that this will no longer be her attorney if the court allows it. July 28th, 2025. Motion to withdraw and request for appointment of new appellate counsel. Okay, Sarah, you wanted new counsel? Have new counsel. Here you go. Have new counsel. Have new counsel. Enjoy your new lawyer. Comes now the undersigned court-appointed and conflict counsel because the first appellate attorney had a conflict. Comes now undersigned court-appointed conflict counsel for the appellant and pursuant to the Florida rules, respectfully moves to withdraw as counsel and requests that new counsel be appointed. In support, counsel states, appointment and procedural posture. The appellant Sarah Boone was convicted in the Circuit Criminal Court and subsequently filed a notice of appeal. Yeah, Owens filed it in the wrong court. But he did file it and corrected it. The undersigned was appointed by the lower tribunal, which the trial court, not the appellate court, that's what they mean by lower tribunal, the trial court, as conflict counsel after conviction to handle the appellant's appeal pursuant to Chapter 27 Florida statutes. A notice of appeal has been filed and the undersigned has complied with the appellate rules by filing the necessary statement of judicial acts, directions to the clerk, and transcript designations. Good cause for withdrawal. The rule provides that trial counsel may not be relieved of duties except with approval of the lower tribunal as good cause shown. This is not trial counsel, though, so I'm kind of confused why it's trial counsel, but that's what he said. The undersigned is no longer practicing appellate work or accepting court-appointed appellate cases, which would make continued representation a hardship. Continuing to represent the appellant on appeal would materially impair counsel's ability to provide effective assistance and would delay or jeopardize the appellant's appellate rights. Sir, you've already been appointed this case. You've already been appointed this case. So if you change your practice and are no longer practicing in appellate work, you took this case in December. So have you not been working on this case already? Also, you say you're no longer accepting court-appointed appellate cases. You accepted this in December 2024. I don't know. This rubs me a bit the wrong way. I understand that Sarah Boone is not an easy client, but it's an appeals case. There's not much you need from the client. Also, you can talk to counsel because she was not representing herself. You can talk to counsel Owens and ask him. And you've got the transcripts. The appeal is based on the transcripts. So he is not saying that the relationship has become untenable. He is not saying that he has an unresolvable conflict. He is saying, I don't do appellate work anymore. And I'm not accepting court-appointed work anymore, but you did accept this case. It's an interesting conundrum because you're no longer accepting cases doesn't mean you can't finish out the cases that you have. And so I saw Mama of a Medic said, could he be ill and can't proceed? That would be indicated differently. It could be the case, but it wouldn't be indicated this way. So it's a very odd, it's a very odd way to ask for withdrawal for me. And I just wonder if he really hasn't contacted Sarah Boone in the last 7 months. Like, I have so many more questions about this, and I wonder if the court will have more questions too, because he almost missed a window to file appeals. There might be other things going on. Normally, though, those would be disclosed to the court. Appeals work doesn't require a ton of interacting with the client. It is mostly based on the transcripts. And then you tell the client, we're going to file this on this day. Here's the copy or whatever. It's an odd statement of withdrawal. There's a lot of other ways to say this. Gold said, could he file for breakdown in the relationship because of harassment? If that was happening, he would generally say it was an unresolved conflict. If he was being harassed or threatened or something, that would go under a unresolvable conflict. So it's just a strange reason for me, because most attorneys, once they've been appointed without good cause, will continue along in a case. And good cause is not, I'm not taking cases now, because this case was taken in December 2024. And I imagine he's already been paid, or at least billed, for the work that's been done, because work has been done. I'm interested what the court's going to do with this, because it is an unusual way to note this. If there were personal reasons that the case could not continue, that would generally be noted. If the attorney was unable to practice for health reasons, that would be noted. If the attorney was unable to work with the client, or the client had made statements that made it a conflict for the attorney to continue, that would be stated in that way, normally mitigated. But Sarah's lawyers have not said that she had threatened them. It had been that the relationship was unworkable because they could not get along. But in trial, unworkable in trial is a very different thing. Unworkable in appeals work is like, okay, yeah, I'm going to file this, just leave me alone, because the appeal happens just on the record. You don't need to interact. Sarah wants them to, but you don't need to interact with the client more than advising them of things being filed. It's very much dealing with the transcript and the rulings from the court. So it's different than trial. The client doesn't need to agree with you on appellate work. In trial, you and the client need to work together in a different way. On appeals, not so much. So this is an odd one. And I could see the court saying no, or saying you need to file something for in-camera review to explain more, because this is not sufficient cause. You have been in this since December of 2024. So how are you now saying, well, somebody else has 60 days. I just filed an extension. Somebody else has 60 days to file it. That's not a lot of time to review an entire transcript. And also, when was the decision made to no longer accept work? Why could this not have been filed sooner? This is an odd thing. Steeler with RSD said, could 9 people be harassing the attorney with the calls, emails, etc.? I don't disagree that that could be happening, but that's not what the lawyer stated. That would generally get lumped into there has been a breakdown in the relationship that has caused a conflict, because the lawyer can't work on the case if the lawyer feels unable to work with the client. So that's not what the lawyer is saying. If the lawyer was saying that, it would be different. Repulsive Artichoke said, how is Sarah not in the wrong here? Because no matter how difficult Sarah Boone may be, she has the right to the attorney that was appointed to her. And they have the right to communicate and should communicate. But the lawyer could have said to Sarah Boone's note to the court, I've communicated with her the status of the appeal and kept her in the loop as obligated. That could have happened. The lawyer's statement of why they want to leave is unusual. But then again, Sarah Boone did say, hey, if this lawyer won't talk to me, get me a new one. And this lawyer's like, fine, have a new one. But also, the court would have been paying this lawyer for the appeal from December 2024 to July 2025. That's not an insubstantial amount of time. And it kind of fucks over another lawyer that comes into this and is like, oh, by the way, you have 60 days to get up to speed and file an appellate brief. It takes time. So it's going to get delayed again. Anon Mouse said, unless something has come up in his personal life unexpectedly, serious illness, himself, family member, but it wouldn't be noted this way. That would be an in-camera of, I can't continue on the case, and that would go in camera. And it would generally read, due to unforeseen circumstances. And I am filing this for the court's in-camera review, and then that would be disclosed. Because yes, lawyers have health problems where they cannot practice, but this is not how that's indicated. What's odd to me is not that the lawyer is trying to withdraw. The good cause for withdrawal doesn't seem to be good cause and is incredibly odd. This is incredibly odd. If there was actual good cause, it wouldn't be written this way. This is strange and a bit confusing. And we've seen a lot of with motions to withdraw in all kinds of cases, but nothing quite like this. Riley asked, what does in camera mean? It means for the judge's eyes only in chambers, so that the judge would review it. And that would be appropriate in the circumstance of illness and things like that. That would be appropriate there. This is odd. And I've had cases where attorneys have had to withdraw because of illness, hospitalization, death in the family, things like that. It's all noted differently because it's pretty easy for the court to assess the situation. This is an odd statement. I'm no longer accepting court-appointed work, and I'm no longer practicing appellate work. It's just an odd thing. Truly. Brianna asked, would it be worded different if the lawyer lost their license? Yes, much different. It would be noted much different. There are a lot of possibilities, but none of them fall under the way this was worded. Because this is a publicly funded appeal, the appellant is entitled to continued assistance of counsel. Rule 9.140D directs that in publicly funded appeals, the lower tribunal should appoint the public defender or the Office of the Criminal Conflict and Civil Regional Counsel or private registry counsel to represent the defendant on appeal rules. The undersigned therefore requests the court enter an order relieving current counsel of record and appointing appropriate successor counsel. This is going to Judge K. So Judge K is the one who's going to have to decide this. Cece said, is there a deadline for her appeal? Yes. And it's already an extended deadline, 60 days from July 1st. This one's unusual. I wouldn't normally cover a motion to withdraw. I would have made a quip about it and moved on. But this is just so weird. Sharon Will said 12 drummers drumming just marched past my house. That's the best day ever. I would need a personal drum line. That's the best day ever. There's a video online of I don't remember which court it was that got a little confused where their practice area was, and they were on a woman's lawn, and you've got like the whole drum line on somebody's lawn, and she's like, but this is a house. And while I understand an unexpected drumline in your lawn might be a surprise and a bit loud, I think it would also be delightful. But if you live in the area where there are high schools, colleges, or DCI performances, I imagine you know that every year that people are going to show up. So I'm surprised by this. It is an unusual request. I'm going to look up this rule real quick because I'm curious. Let's see. 9.140. Just bear with me real quick while we wander into the rules. I am not a Florida attorney, and I am curious. Evil Oddish says, does this create an additional appeal issue? No, it doesn't. It creates annoyance for Sarah Boone. She's going to be annoyed by this. However, this is what she asked for. She said, if this lawyer won't talk to me, get me a new one. And this lawyer immediately was like, get the woman a new one. Get the woman a new one. Let's see. We're going to pull up this rule real quick. And what subsection? D, Emily. It's always the D. Go to subsection D. Let's go to subsection D, shall we? All together. B, C, D. Withdrawal of counsel after judgment and sentence or after appeal by state. 1. The attorney of record for the defendant shall not be relieved of any professional duties or be permitted to withdraw as defense counsel of record except with approval of the lower tribunal on good cause shown on written notice until either time has expired for filing an authorized notice of appeal and no such notice has been filed by the defendant or the state or after the following has been completed. A. Notice of appeal or cross appeal has been filed on behalf of the defendant. That's been done. B. A statement of judicial acts to be reviewed has been filed if a transcript will require the expenditure of public funds. That has been done. James Owen did those two things. C. The defendant's directions to the clerk have been filed if necessary. That's been done. D. Designations to the approval court reporter or approved transcripts have been filed and served by counsel. That's been done. So all those steps have been done. So the steps have been met for this attorney to be allowed to withdraw. The rules are actually pretty cognizant of saying you can't, I'm saving two comments real quick. Those are good questions. Chat, I'm going to come back to them. You can't yeet yourself off a case until the defendant is in a position where they're not going to lose their rights. So you have to make sure that the defendant is in a solid position and isn't going to miss a deadline or something like that. There are steps you have to take before you can leave. You can't leave yet. But these steps have been made. So we have under D1, A, B, C, D, those have all been met, which is why the attorney outlined them in their motion. Your Honor, we've done all the things we're required to do by section. D1D says designations to the approved court reporter or approved transcripts have been filed. That's been done. D1E, in publicly funded defense or state appeals, when the lower tribunal has entered an order appointing the office of the public defender for the lower circuit, the district attorney of criminal conflict, or the district office of criminal conflict and civil regional counsel or private counsel, the office or attorney shall remain counsel for the appeal until the record is electronically transmitted to the court. In publicly funded state appeals, defense counsel shall additionally file with the court a copy of the lower tribunal's order appointing the local public defender or the other offices. This attorney is appointed from the other offices. And in non-publicly funded appeals, it doesn't matter. So it seems that all of the steps have been taken that need to be taken if the court is going to allow it. It goes on to say orders allowing withdrawal of counsel are conditional, and counsel shall remain of record for the limited purpose of representing the defendant in the lower tribunal regarding any sentencing error the lower tribunal has authorized to address during the pendency of the appeal. That's not happening here. That's not pending. So the steps that need to be taken have been taken. I still don't know if the court is going to allow this to be withdrawn. The reasoning is odd. My camera just got odd. Sorry, y'all. I don't know what that is. My camera just was like, what's happening? Where did you go? I wonder what the court's going to do, because the stated reasoning is strange. But all of the steps have been completed that the court could allow this attorney to yeet out of this case. But it really just puts another attorney in the, I guess now we're starting over. I mean, not from zero, but starting over with reviewing all the transcripts. Ultimately, it ends up slowing everything down and costing everyone more money. But I don't know. I guess the defense attorney might be like, well, she's not going anywhere, but that's not a reason to slow down the appeal. However, Sarah Boone's grounds for appeal are not readily apparent that there is a modicum of chance of success. Her level of appeal is not one of the appeals where you look at it and go, that's a really interesting question. I wonder what the courts are going to do. You look at Sarah Boone's appeal and you go, I mean, good luck with that. We'll see how that goes. The court and counsel were incredibly conscientious going through this case. I don't think that there is going to be good cause. I'm just looking for one more motion. I don't think there is going to be good cause for appeal on the speedy trial issue she wants to bring. I don't see her briefly having to represent herself going very far on appeal, if far at all. There's just not much there. And some cases are like that, where the case proceeds, the evidence is strong. Some of the large motions that the defense wanted, they won. She was allowed to present her defense. So, I don't really see this going anywhere on appeal. I'm very interested to see what the judge does with this. I'm also interested to see if, here, I'm going to look real quick and see if counsel has any indication on their website or anything. I'm just going to go look real quick. I didn't do it before stream, so we're going to just explore in real time because I'm really curious. Let's see. Let's see if there's anything we can see from the law firm. Let me see where the let's just do this. Well, there's the law firm. Let's see. We're just going to do it together and see if we can discern anything from this, but we didn't look at it before, so I don't know. This is the law firm. They have their practice areas listed as criminal, probate, civil litigation, eviction, and person. I mean, that's a wide gamut of practice areas. Criminal defense. None of that indicates appeals, but I wonder if it would have before, because he was appointed through the panel of conflict counsel. So, trial and litigation, including criminal defense and civil litigation, sure. But I can't imagine that. Well, none of this indicates that he did appellate work, but he was on the panel. He might not have advertised it and took appellate work as part of panel work. Why is that? So I just don't. I don't know, but I'm sure the office getting constantly called and emailed is not their favorite. But none of this indicates appellate work. I don't know if it did before, though, because a lot of panel attorneys do not indicate that they do appellate work. Also, it's a wide gamut of practice area. All right, well, we'll see. Adrena said conflict counsel would be such a cool band name. It would. The lawyers would be like, wait, what? Yeah, okay. Worked as a prosecutor, private attorney, boutique law firm, family law. Okay. Well, I guess we'll see. I mean, if you don't want to be appointed, though, don't be on the panel for appellate work, because you have to like opt into that. You don't get voluntold that you're going to do appellate work if you don't do appellate work. I'm very interested. Ooh, Jacqueline said, what about LinkedIn? I don't know. I'm curious. Let's see if there's anything new on the docket. When I checked last night, there wasn't, but who knows? Let's check today before we just go to Q&A on this. It's really strange reasoning to me. I am interested to see what becomes of this notice, because this is within Judge K's discretion, and Judge K gets to decide what happens with this. And if you're not opened for appointment, don't take the appointment, or don't be on the panel where you can take the appointment, because there are also rules about being on a panel where you can be appointed. So I'm real curious. I'm pulling up the docket. I'm real curious where this goes. But also, it's not good for anyone if you force an attorney to stay on a case. And that might just be the answer. So there is nothing on the docket other than that last notice, but I'm actually going to be keeping a closer eye on this docket, because I'm real curious. But the index to record on appeal got filed in May. Something happened in here. The transcripts all got filed. The court reporter had asked for an extension of time. The court reporter's like, I need more time to get the transcripts done. That's not unusual. That was ordered. The court reporter got more time. The transcripts were filed. The appellate transcripts were filed. The index on appeal was filed in May. But then, interestingly enough, in June, you have an order from the appellate court. June 13th, 2025. In the District Court of Appeal for the 6th District, within 20 days from the date of this order, appellant shall serve an initial brief, or alternatively, file a response that shows cause why this brief should not be dismissed for failing to timely serve an initial brief. If appellant fails to timely comply with this order, this case may be dismissed without further notice or opportunity to be heard. So there was a deadline issue in June with a, hey, the appeals have been filed. Why didn't you file? And then we can't see the motion, but the extension of time was granted on July 1st. And I don't see the motion anywhere asking for the extension of time. Let's look one more time. Because in June, it was like, yo, your shit's late. Why have you not filed the appeal brief? Then there was a motion to extend, and the court said, fine, you can have 60 days. And now it's a get me out of here. It's just odd. All right, let me pull up a different docket, because this docket is not the appellate docket. This is the court docket that we have. So this is the court docket that we're looking at for Judge K. So when Judge K makes an order, it will be here and we will see it. We've got all of the other things that happened. This attorney was appointed in December. Notice of appeal was filed. A counsel was appointed. All of that happened pretty quickly after sentencing. Linda D said, it's Sarah Boone. Is it odd the attorney wants out? It's not odd the attorney wants out. It's odd that the attorney filed it that way. The court appointed Adams on December 18th. So I do not know why the orders from the court indicate anything different, because I don't see, they aren't, hold on. Here's where the confusion is. They are not addressed to Owens. They are sent to Joshua Adams. The clerk is named Owens. That's the clerk that signed these. It's not going to Attorney Owens. No, it is CC'd to Attorney Owens. This is her lawyer. The Attorney General got a copy. The clerk got a copy, and James Owens got a copy because he was previous counsel of record. But it went, this is appellate counsel, Joshua Adams. Hopefully that makes sense. I know we went through it quickly. But it was a good question. Okay. Let's take a look real quick at the appellate docket. No, I'm glad you asked, because again, if it's confusing, I rather clear it up. I'm glad you asked. I was like, wait, let's go back and look, because there's definitely things I don't catch. And you guys let me know when I scoot through things too quickly and you have questions, and I want to answer the questions. You've got questions. I've got answers. If I don't have answers, then we'll all have questions together and we'll figure it out. Speaking of which, for all of you that are going to ask, Emily, did you find the word that Alessi was talking about? Not yet, because the Karen Reed files are not OCR'd. So it's going to take me a minute to find that motion, and I couldn't find that motion. I don't know if I have that motion, so I'm going to have to go track it down. But I'll find it, because now I'm determined. We'll find it. Or I'll ask him if he can send it to me. I'll be like, can you just send me that filing? I can't find it. I can't find it. Just send it to me. Just send it to me. Okay. So let's see. Let me pull up the appellate docket. It's such a strange way to ask to withdraw from a case. I've never quite seen anything like it. And I could see the judge being like, that's not sufficient reasoning. You need to explain yourself, because when you were appointed, you took it and you need to finish the case to the end. It's like, I don't know. When my kids were young, Emily, when my kids were young, I'm pulling up the appellate docket as well. When my kids were young and wanted to play sports, part of the conversation every year that I would have is, hey, you can play whatever you want or not. I want you to try things like try baseball, try soccer, try different cases, or try different sports. That's fine with me. But if you are going to start a season, you have to finish the season unless you cannot. Like if you are injured, obviously you cannot. But you don't get to just be like, nah, I don't feel like doing this anymore. You committed to your team. You are there. You have to finish the season. And it's kind of the same thing here, because the I don't do this anymore is not sufficient good cause. So I can see the judge saying no. I can see the judge asking for more information. All right, let's pull up the appellate docket real quick. Also, if you see that the light on my face keeps changing, I'm having issues with my external monitor. Delightful. So, a lot of you have like, it could be these things, which I get, because I don't know. I am kind of baffled by this one, and I'm buffering in real time. Let's switch this real quick and look at the appellate docket together. I looked at this yesterday, but we're going to do it together. It's just so odd. I think what I was saying is there's a lot of reasons why an attorney could leave, and none of these reasons are explained by what was said. Injury, illness, it isn't explained by what was said. Disagreement or unworkable situation with Sarah Boone or the people that are calling the office all the time isn't what was said. Like, all of the things that could be are not what was said. Odd, odd, odd. So here's the motion for extension of time. Documents are not available. I might have to send an email and be like, hey, why? Because the order to serve brief is there, but we can't get some of these documents, which is frustrating. So I'm going to try to find the motion for extension of time, because now I need to know. Now we can't let it go. Now we can't let it go. Yeah, I'm not sure what this is. A number of you are saying that Peter covered it. I'll go take a look. For sure. I'll go take a look. I haven't had a chance to watch yet, but he's in Florida, so I'll go take a look. Oh, Ems, no, my session didn't expire. That's just, I appreciate the tech help. Nope, this isn't a login. This is the court, because there's the motion for extension of time. This is a regular issue, even when I am logged in, because you can get the orders. I'm going to reach out to the court. Don't worry about it. We'll figure it out. So I'll go take a look. No, I'll go take a look. Thank you for letting me know. But I'll go take a look, because I've got most of them, Peggy. If the appellate court isn't publishing them, there's not much I can do. So let's go to questions. The amount of knowledge I have about different websites across this great nation is substantial and extensive, but not every website works the same way. All of them are different, but we'll figure it out. Because even when I am signed in, I couldn't get those. I'm just going to reach out to the court and be like, this shouldn't be sealed. It's an odd thing. So no, but we're not going to let it go. If it was just, I feel like I've overstated it now and I'm repeating myself. If it was just normal process, I would have just said, the attorney said this, and that, fine. But it's not. The explanation is so odd. And it doesn't account for any of the things that might actually be good cause. So there is something amiss. I don't know what it is. We don't have enough information. But I no longer practice this and I don't take cases now is not going to be good cause. It's just not. Skeeter said dog with a bone mode activated 100%. I need answers. I need answers. I need answers. Let's get to questions, because I also need to check the time, because I have a hard stop today. Why do I have 11 text messages from my kid? Hold on. I agree with you. Nico in the chat said, my gut says this is not related to Sarah Boone. It's probably not, because if it was, it would have been stated differently that there are differences, or he would have just said, look, my practice has been so disrupted by those contacting us because of her that I actually can't represent her anymore because I am now conflicted, or just saying it's a conflict. But that's not what's said. So it's really strange. Let me double check, and then we will, let's see. Oh no. These are DCI things. Squinter has entered the core for the first time. For the first time this season. So Travis had to let us know that Squinter is Squinter is what's happening because it's almost the end of the season and the Gatorade is gone. Oh boy, that's an if you know, you know. Let's get to Q&A, shall we? If you're going to ask me questions about Squinter, I'm going to let someone who marched core explain in the chat because not my monkeys, not my circus. Let's get to questions. All right. You guys have lots and lots of questions about all of the things. Paris Dew said, can the appellate attorney just say there's no reason for the appeal or do they have to try something? There were a few grounds for appeal that might not be the strongest grounds, but there are arguments that can be made on case law, like forcing Sarah Boone to represent herself, though I think it was within the court's discretion. There's always room to ask the court, hey, she was forced to represent herself for this period of time, so that's not allowed. There are things within the world of any given case that can generally be argued. And James Owen, actually, let's just pull it up real quick because I haven't looked at it in a while. James Owen filed the notice of the areas of appeal. It's just been a minute, so let me grab it because though I don't think there's strong arguments, there are still arguments that they are going to make. And an attorney can really generally find something because the court's going to rule against them on something. From what I remember from James Owen's arguments, it was the period that Sarah Boone was forced to represent herself, the amount of time it took to go to trial, that a continuance wasn't granted. Again, it is an area to argue. I don't think it's the strongest one, but it's an area to argue that, look, the attorney came in and needed more time and didn't get more time. So he's going to argue for that. They're mostly the grounds on defendant's motion for new trial. So we're going to take a look real quick. The court erred in ruling that the defendant was not entitled to court-appointed counsel. So that's the period of time she had to represent herself. The court erred in denying undersigned counsel's multiple motions for continuance. The court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of jury prior to deliberations. By the way, for those of you that didn't watch it, they left the court when photos were shown. But again, it's something you can argue. Look, there was emotion, strong emotions in the courtroom. The appellate court are going to say if this was error, then it was, which I don't think they will, but if it was error, it was harmless because the evidence was so strong. And 4, the trial court failed to disallow the opinion testimony of the state's rebuttal expert witness. And 5, the state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument, which is the weakest of all of the arguments. But they have a few things that they can argue. And attorneys will find a few things in any given case where the court ruled against them, even if it's minimal, that they can argue. So Your Honor, there are no good grounds for appeal is definitely not a reason to be taken off a case you're appointed to. And again, when you are on, and different jurisdictions do this differently, oftentimes public defender's office will have a branch that does appeals and they get appointed first. So it's a public defender case, then the public defender's office will do the appeal. The public defender's office in this case conflicted out, the appellate public defender conflicted out, and you got into all of the different appellate or all of the different conflict counsel. And normally each jurisdiction has a list of attorneys that are available to be appointed on a given case who also work their private practices, and they have rates that are pre-negotiated and they get appointed to the court or to the case when the public defender's office and the other office can't do it. So because of the prior conflicts, attorneys from those lists, panel, however the jurisdiction calls them, get appointed. And that's the same thing that happened on appeal. James Owen is like, I'm not representing her for appeal. He had parachuted into this case and said, I'll take this case for the purpose of trial, and that's it. But I'm not representing the appeal. And so appellate counsel was appointed. And the first time appellate counsel was appointed, the first appellate counsel had a conflict. So this counsel, Adams, was second appellate counsel who got appointed. And so now the court has to go back to the panel of lawyers and find another one to appoint off the list. So let's continue on with that. It's good to see everybody. Thank you for your member chats. It's so nice to see everybody saying hello. One of the best interviews with Mr. Alessi yesterday. Thank you, Fifi. I appreciate that. I wanted to get to know the attorney Alessi, or anyone we talked to. I want to get to know them a little better. We did the same thing when we talked to James Egan from Gwyneth Paltrow's case. I love having those conversations. So Vasilette, I have reached out. I suspect that because of the movie and book deals, we will probably not hear from Attorney Jackson, but we may. Again, we wouldn't really be talking about the Reed case as much as talking about Attorney Jackson. But when there are deals in the works, we will see how that goes. We did make fetch happen, Donnie B. I saw all of your comments yesterday being like, we have gotten to the end of the Karen Reed trial and we finally made fetch happen. It was very, very kind and very sweet. So thank you guys for the comments. It was great. Brooklyn Duncan said, listening in the background today with a mega pint of coffee while we're in the final stages of wedding planning. Oh, it's busy. Just everything will be fine. Everything will be fine. And the things that are not going according to plan, nobody knows but you and a few people. It will just eat, drink, and be merry and spend time with people, and it will be fine. It's really hard to do in the moment, but it will go too fast. Jay McCarthy said, 32 months, another milestone. I'm glad you love it. Kay said, I use the books for university. I have seen lots of good reviews on the books. It is on the list. It is on the list. Jen said it, not me. Jen said details matter, right, Mr. Brennan? Janine said, on the set working, but you are in my ear. Thanks, EDB. You are welcome. I hope you're having a good day at work. Emily Ippolito said, I looked up Brennan's website after the trial was over. Once you see that, the typo in this motion isn't surprising at all. Oh boy. Matt Future ESQ said, are we sad to see Hank go? I'm not. I was so hopeful that a fresh set of eyes would bring some more clarity to that case. After watching the testimony with Adam Lally, and again, we will watch the next day in court if it is streamed. After watching the testimony with Lally, I realized that maybe my optimism was misplaced. And it, especially after Attorney Brennan's statement after the jury saying, I did an investigation and there's only one way this could have happened. I can't wrap my head around how he gets to that conclusion. I've tried. I cannot. And I can't get my head around, even if Brennan thinks, yeah, 100% Karen Reed did this. The problem is, if you're a prosecutor, there's a second step to that evaluation. Like, I know some dude did it is not sufficient to file a case. It has to go the step further of, and this can be proven beyond a reasonable doubt. And I don't know how they got there, but after seeing Lally testify, I don't know if they're asking those questions. Ethically, they're obligated to. But I'm concerned that those questions are not being asked. It feels like everything is just, it'll be fine. No, that's not how that goes. Ugh. Jeanette in the chat asked, do I spy Cavaliers nails? I did theme them to shapeshift. I did. They are shapeshift themed nails. I did do that. Heather says you can't run on vibes. Correct. Not in this. Other things vibes. This not vibes. Smurfana asks, what if the phones and Lexus indicate more subterfuge? Well, then there will be lots for the lawyers to do, won't there? Aileen said they can't keep them for that reason. Aileen said, as a former drum major, I'm here for all the DCI season commentary. Love when my worlds collide. I know we're going to have to do just a separate band commentary. Jade Zia, I think I got that right. 1969 said, stalling until Aiden's case is over. Perhaps they don't have legal cause to do that. So they might want, I don't know if they want to or not, but they don't have cause to do that. I'm DeCrow 76 said, when they get it back, we'll see what was tampered. They might not. So the phones and stuff should have been returned after they were dumped. The car makes sense to keep until trial's done. But even then, it's going to be wild. So let's see. Cashmere and Coconut said, not shocked. In fact, I expect them to try to charge her impound fees because I checked and it could be $100K plus their fee schedule, plus per their fee schedule. It will be interesting if they try. I imagine her lawyers will lose their minds if they try to charge impound fees. FBI Ice Cream Truck said, has someone checked Proctor's desk? I mean, somebody check the drawers. Liv said Aperture should just give Karen Reed their Lexus. Yeah, they're going to sell that back, but I like the optimism. But yeah, no. Beck said, after your great combo with Alessi regarding linguistics, I have a word of the day for you. Susurrus, meaning rustling. The susurrus of Alessi's papers in the microphone deafened the courtroom. I love it, and I love that we got to use it with a sentence. I'm here for it. Let's see. M asked, when are we going over the Idaho docs? It's gonna be a minute. I have not had a chance to go through them all. I am not going to go through them on stream as a first look because some of them are going to be much. So we are going to go through overviews of them, but truly I needed a minute to catch up on some of the other cases. I also want to take them with me with some more traveling so I can start to go through them, but I am not going to, we don't have time in the world to read them line by line. I hope to overview them for everyone so we can take away the legally relevant parts and leave some of the more graphic, horrific, and disturbing details. It's a hard case. It's really a hard case. And so it's just going to take me a little time to parse through them. And we're going to be coming up on the Adelson case. So, Laura, I have covered the TikTok defamation case. There's nothing new. So when there's something new, I will let you know. We are all caught up on that case. We are caught up to every single document. So let us continue. Miss Scarlett, congratulations. Miss Scarlett said in a member chat, oh my God, you guys. That was my inflection. I just got a jury duty summons. Yay. Yay, Frau. Enjoy. I hope it is a good experience and that the chairs are comfortable. Mm-hmm. J. Michael RN says, sounds like, nuh-uh. Right. Nuh-uh. We don't have to give him back. It's so dumb. Tina KS, Leonard, good to see you. Said, could it be that he has a full caseload and can't in good conscience be able to continue to represent her? Not really, because it's your obligation if you aren't able to take the case to not take the case at that time and then to not take subsequent cases it's like first in, first out. You have to be able to handle the cases you've taken. You don't get to take more and be overloaded. Also, if he was unexpectedly in trial or something like that, it would be filed, hey, I'm going to be in trial for these months unexpectedly, and therefore I can't. It would be noted different. But no, taking on too much work on your own is not good cause. It's bad planning. It's kind of like your failure to plan is not my emergency. And Katie R. said, in the hospital with preeclampsia, I'm happy to have come across a live stream today. Maybe this will bring down my blood pressure. We didn't talk about Lally much, and I have been there, Katie. There's not much you can do on the blood pressure. So good luck. I hope you feel better. I felt like absolute shit throughout my pregnancies and had horrible preeclampsia. So I do not wish that on anyone, but everyone is healthy and well. So take care of yourself and try to get some rest. Resting in the hospital is the freaking worst. Oh, I feel like crap when I can't even talk about it. No. Also, some of you in the chat have said with the overwork, it's what Griffin would say. That's a skill issue. Griffin, quite snappy with that sounds like a skill issue. It is a planning issue. It is your obligation. Nightshade said, what happens to Sarah's appeal if she can't keep an attorney? Would she ultimately run out of time? Not really, because what the court ultimately would do is say, no, the appeal's due. You're the attorney. File it. And then if the attorney doesn't do it because the notice of appeal and other things have been done, a subsequent attorney would be able to say this was counsel's fault. It wouldn't waive her right. And courts really do try to protect, if there is attorney error, try to protect the rights of the defendant. And there has been a 60-day extension. So no, she should not get hosed in this. It's not her fault. Like whatever's going on with her attorney is not her fault. Her attorney said nothing about her in any of that. Her attorney said, I just don't do this anymore. Frankie's Fine said, is the attorney who is no longer doing appellate work due to the scandal regarding public defenders being unpaid? The no longer doing appellate work is in Florida, and this is a privately appointed attorney, so it's not the defense attorneys. And I think that was in Massachusetts. So, IR Miklat said, if all the criteria was met, what was he working on? He needs to file the appellate brief, and that hasn't been filed yet. All of the initial steps are done, but then you have to take the transcripts, the law, and the issues and file the appellate brief, which is the hardest part. Appellate briefs take quite a while. Let's see. I saw a couple of you asking how my knee is doing. I have some imaging coming up. So it's not great, but we have a workable plan. So we have some imaging coming up. Emily C. asked if I could go over the whole Proctor iCloud FBI protective order 30 days situation. I have not pulled it up. I have seen that there is more stuff going on in the other cases that Proctor has touched. It's on the docket. I have just not gotten caught up, but it's on the docket. Alyssa said, did someone check in their closets and under their beds? That's where I used to hide things as a kid too. Yeah. Or I would lose things under the bed. I would forget that I put it there because my mom would be like, clean your room. And I'd be like, it's out of sight. And then I'd be like, shit, where'd it go? Item permanence is an issue a bit. So it is an issue. Crazy Cat Queen said, have you ever seen a case where an attorney just threw up their hands and quit being a lawyer because of a case or client? No, I haven't. I've seen some things go spectacularly wrong in court, but because I was a prosecutor, when things started going off the rails, I was normally already gathering my things because you could tell when the defendant was about to start saying, and my attorney's not doing this. And those are hearings that happen without the prosecutor present. Those are between the attorney and the client. So I would start gathering my things and be like, I'm going to be outside. You could tell they were going wrong. But I worked with a lot of great attorneys who worked for the public defender's office, and they put up with so much bullshit. They put up with so much bullshit. And it is a level of patience that I don't know if I could have. I mean, you see defense attorneys share these stories and you see them over and over again, but attorneys who are told, you're pretty all right. Maybe one day you'll be a real lawyer. It's like, no, public defenders are real attorneys. They've passed the bar. They've chosen to do this. In fact, you're here because you can't get a real job. They would, I don't know if this is nationally that they would get called public pretenders, but there's a lot of difficulty within choosing to be a public defender. I know they have great clients too, clients that appreciate them, clients they do great work for, but there's a lot of clients that do not appreciate them. And you get appointed. You don't get to pick your client. You get to pick your client in private practice, and your client gets to pick you. The relationship is different. When the client gets stuck with you, they're like, well, you have to give me a lawyer, but I don't like this one. It's like, well, you don't get to choose. It's a hard job. It is a hard job. And so it's wild, but no, I've never seen anyone quit the practice of law. I have seen incredible amounts of patience, because also the thing about being a public defender is you have to tell your clients the truth, and they don't like often the truth, but it is your job to tell them the truth. And that can be difficult because there are people who do not want to hear it. As the prosecutor, it is a much different role, and there are other people mad at you, but the defense attorneys have to build as best they can a trusting relationship and also tell their clients the truth of what it is. And not all attorneys do that well. And there are definitely clients that feel like they are just another number in a list of cases. I get that, but it is a hard job. Also, you don't have any control of what the DAs are doing. You get assigned a case, you get whatever's filed, and you do not have control of whatever the fuck the DAs are doing. The DAs get to choose that. So I am not that patient. I am just not. This surprises no one. Shelby said, not a question, but I truly enjoyed your interview with Alessi yesterday. Thank you, Shelby. That is incredibly kind. Laura M. asked earlier, will it be from both trials? The sidebars will be from both trials. I will see. Before I commit to reviewing it all, I will see how long it is, because it might be difficult. Bobbit said, knee issues, same, waiting to get the surgeon's schedule for a replacement. Bobbit, I was told optimistically that we are not there yet. However, when I had my ACL replaced quite a while ago, when the doc was done with the surgery, the doc was like, so at some point this knee is not gonna be working any longer. So do your best. And eventually it's going to need to be replaced. Your knee is not great, but some of that is just genetic. So we'll see. Jojo, I know I got asked about this yesterday. I do not know this case. I did not have a chance to look at it. I will take a look. I have just not had a chance because I was prepping for stream and then trying to find a way to read all of the documents in Idaho and then in cases for the podcast. I have not had a chance to take a look yet. But if it falls within the types of cases we cover, I will take a look. But I do not know yet just because I haven't looked at it. The real Melon Lord said, theory, they are keeping the phone and car just to play silly games. That might well be the case. They can't. And they need to give the things back. And they should. So we will see. But knees are rough. I had a hip replacement last year and know that it is so worth it. Everyone I know has said, oh my God, it's so worth it. So, the orthopedic stuff is one of the things that has been a lifelong struggle, and it just is. So we're getting some imaging and doing our best, and I'll keep you guys in the loop, but it will be, it's not new. It's just me. So it's not new. Allison asks, what has brought about the orthopedic issues? Unknown at this point. It just happened. So something was just done, but we'll see what imaging says, and then we'll go from there. I'll keep you guys in the loop. It just is. So that's orthopedic stuff. I mean, and for those of you that have repeated orthopedic stuff, I have had repeated joint and ligament issues since like junior high school. So this is not new to me. And it's one of those things when I look at my folks, I'm just like, I mean, yeah, same with my mom, same with my dad. Some of it's genetic. Gemma, I am hypermobile. So we don't have a ton of stability in the joints, and a lot of it's just genetics. So it is what it is, but I am well familiar with the orthopedist office, and I get to talk to lots of doctors. So it's fine. It just is. But I'll keep you in the loop. Look, I can still get up and down stairs mostly. So it's fine. It's just uncomfortable. I'm just more tired because I'm not sleeping super well. And that's hard. So that's the most annoying part. But having answers helps. It's, honestly, I would rather go to the doctor and have the doctor be like, ooh, you got stuff going on. Like there's stuff. Than going to the doctor and having them be like, I hear what you're saying, but I can't find any reason that hurts or that this or that. That's the worst. And then you start getting all kinds of weird things like maybe it's your hormones. I mean, at this point, maybe it is actually, but it's frustrating when there aren't answers. It's helpful to know we have some things going on and can get some imaging and figure out some more answers. That's better. Like, we don't know what's happening is really frustrating. Really frustrating. So that is, that just is what it is. So yeah, it's all right. Look, it is something I'm well familiar with, and it is something that I am just, yeah, exactly. Have you tried exercising? Actually, yes. And then everything hurts. But yes. So it's one of those things to know that there is stuff going on, but also it's been kind of a chain of events, right? Just the knee that's bothering me has had multiple surgeries on it, so that's not surprising. I've had a spinal fusion. Spinal fusion kind of changes your gait a bit. That's not surprising. I've had ankle instability. So the fact that the knee is also mad, that's not surprising. As one gets older, that's also not surprising. So it's just trying to navigate taking the best care of myself and my joints so that I can continue to like get up and down bleachers and stairs and all the things we want to do. I just want to be mobile as we continue on in life. So I'll keep you in the loop. But with all of it, what did we do today? All the things. Karen Reed wants her shit back. There's no reason she should have had to make motions to get her shit back. They should have just given her back her shit after the trial was done. That's the best summary I can give of today. Give the woman back her stuff. This shouldn't be hard. It maybe it takes a minute to negotiate like a tow truck. But even then it's, hey, on these days you can bring a tow truck and come get the Lexus. Like this shouldn't be hard. And Sarah Boone's attorney has something going on, and it is strange to me the way that attorney is asking to withdraw from the case. It's not falling under the realm of what I would expect to see. So for those of you that are in the Lawnerd app, I will keep you posted about streaming. I should be streaming on Tuesday. That is what I think I am doing. What topic are we covering Tuesday? It's really going to depend on how much I can get done and how much I can catch up on. Members, we are going to be popping in and doing some tech testing. I will let you know when that is in the app and in the member spaces, because I have some stuff I want to try out for our new streaming software. I want to get stuff kind of dialed in before we get to, well, the Adelson trial. And then I also have some, like, we have life stuff. It is getting to be back to school. For those of you that are like, school's already starting. For us, it is. Emily, Travis is still not done with DCI. Yes, the school's been very helpful. And so we get to go pick up T and get him home soon. And I am so excited. Also, it is getting to be back to school. Also, I have high school band parent duties. So it's going to be a busy few weeks. I will keep you in the loop for everything in the Law Nerd app. Members in the member spaces, we will do a tech test. We will talk about organization and band. I will get more into all of the behind the scenes. If that is the type of conversation that you very much enjoy, you can join the app in the Law Nerd Lounge. You can adventure with me as I explore all the things so that you don't have to in a hyper-focused type of a way. We'll talk about it in the member spaces, and I will decry my this, that of trying to find a system that I like. But do not follow in my footsteps until we're done, because I am going to make a ton of changes between now and whatever I find. I will try all the things, but do not follow me on this rabbit hole. It will end up being like a wait, back up, we're not going that way. Wait, back up, we're not going that way for quite a while. But when I have a final option for now, like the desk reorganizations, right? I went through like 6 iterations of setting up the office. When we get to the end of what I think is a workable solution, I will keep you in the loop, and we'll talk about that more in the member spaces. So with all of it, Law Nerds, you are the best. Stay in the loop. I will see you Tuesday. We will talk about all of the things. I will go take a look at what's going on in the other cases. We should have a hearing that might be Tuesday. If it is streamed, the continuation of the hearing with Adam Lally, we'll just stream that on Tuesday. I want to make sure that we can find it somewhere. So I need to take a little bit of time to look at that. If you want to make sure you don't miss anything, make sure you have the Law Nerd app. That's where we keep you in the loop, because we know that YouTube does not always notify in a timely way. And again, finally, a huge thank you to our sponsor today. Go try Love and Pies. Use the link down below to get some fun goodies as you are playing through day 3 for some cozy, casual mobile gaming. And with that, Law Nerds, it is great to see you, and I will see you soon. Let's roll the outro and let's get going. I'll see you guys next week. Well, members, I'll see you before next week. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.